Hello, good morning, good afternoon, and good evening to everybody who's attending this session. I would like to welcome you to the webinar starting now. The webinar name is the disruption to arbitration proceeding that may represent a strategy to win the merits of a dispute. This is your moderator. My name is Mohammed Elayan. I am a senior project engineer at Qatar Fuel WAQOD. I am also an arbitrator and an expert in Qatar. And also I am a CIArb Qatar branch board member. The speaker today is Ms. Virginia Kolayutta. She is a partner of London office of LMS Legal. She acts as a counsel advocate and arbitrator in international arbitrator proceeding, deriving from construction and energy projects, also based on bilateral and multilateral investment treaties. Virginie is admitted to practice in England and Wales as a solicitor. In New York, she is an attorney at law, and in France, she is an advocate à la cour. Virginie also teaches investment treaty arbitration and conflict of law in relation to construction projects and construction law at King's College. And she is the chair of editorial board of Law magazine in Construction Law International. There is a publication of International Construction Projects Committee of the International Bar Association. Virginie is current member of the executive board of Italian Society of Construction Law. She is also considered as a thought leader for Who's Who Legal, and she is recommended as an expert by Legal 500. We also have at the end of the session our special guest, Engineer Ahmed Lansari. He is the technical office manager at the Public Work Authority, and he is the CIArb Qatar branch president. This event and webinar is sponsored by the Chartered Institute of Arbitrators in Qatar and QFC branch. We thank the branch for sponsoring this event. We are also sponsored by the Qatar International Court of Dispute Resolution Center. And we would like to thank its CEO, Mr. Faisal As-Sahuti. We would like to introduce also our CIArb Qatar branch. Qatar branch has been open since February 2018. We have a total board members of 13 people, and we have a total local members of 215. The branch is also working with Qatar International Court for Dispute Resolution Center, and we have an MOU signed. We would like to welcome all members and all people who are interested in the arbitration and interested in the expert works to join our CIArb Qatar branch to mutually benefit from all the courses and all the events that we are hosting. For any further contact or any further information, you can contact Franco Solano, and his email is shown at the screen. Without any further delay, I would like to welcome Ms. Virginie Kolayutta to take control and start this interesting webinar.
Thank you, Mohammed. I will share my presentation if you allow me. Thank you very much. Yeah. So I'm very glad to be part of this event. This is my second time this year, and I have to thank thoroughly Mr. Hamad Al-Ansari for the support and for the interest on this topic, together with Mohammed Elayan for the presentation, which was very nice, and especially Nurul Sabri, who is one of the most extraordinary organizer of events I ever met. The topic of today is a topic which is the result of some experience, personal experience in arbitration proceedings where I acted as a counsel. And some of this experience, I think, could be useful for many of you who have the chance or misfortune to be involved in arbitration proceedings which are disrupted by losing parties who attempt to win the case, even though they start from a losing position. So the arbitration is usually chosen because of its procedural flexibility. It allows to have the procedure adjusted to the requirements of the case. However, such a flexibility is often abused by a party having a losing position on the merits. Such a losing position may strategically act in order to disrupt the arbitration proceedings to overcome its difficult position on the merits. And some of these procedural arguments and strategy that can be adopted for that purpose may indeed affect the overall result of the dispute, so that a party's right who legitimately started the arbitration can be frustrated in its attempt to have justice because of the exploitation of procedural initiatives and the distortion of procedural arguments. Some typical procedural arguments and strategies that a losing party may adopt include to argue that the claim is time-barred, and obviously as a result you will not have arbitration ongoing, or the claim is not mature. It can challenge the arbitration agreement and the arbitral tribunal's jurisdiction, so that arbitration proceedings cannot take place. It can challenge the independence and impartiality of the arbitral tribunal, and can also initiate parallel proceedings in order to transfer the dispute to a more favorable forum or to a different arbitral tribunal if the arbitral tribunal that was appointed in initial arbitration proceedings did not sound inclined to respond positively to claims which were not sounded. Another initiative is to block the arbitration with anti-arbitration injunctions issued by national courts. And overall, the attempt would be to increase the complexity of the dispute and create procedural incidents so that, including the bifurcation or the application to stay the proceedings, in order to exert pressure on the opposing party so that the latter would settle for a lower amount or would give up because of the high litigation costs or the time involved in the arbitration or the complexity in general, since the multiplication of procedures is difficult to follow for some companies.
Well, you know.
The very first issue...
When I started the presentation, my document just got hanged. And then I got my other paper and started reading from it.
Sorry, Mohammed, are you muting yourself? Did you mute yourself, Mohammed? Or
yeah,
you
I don't know was, but sorry for that. I think I have.
Thank you very much. In the very first issue was that needs to be resolved when an arbitrator must address any question in front of him or her is to define whether a particular issue is procedural or substantive. Because depending on this decision, a different rule may apply, a different law may apply, and the result can be, in fact, different. If one possible approach to this issue, to resolving to identify the applicable law, the applicable rule, is to follow a conflict of laws approach. So that means you first define what is the national law that would apply to a particular question. And for instance, you could refer to the law applicable to the merits of the dispute, or to the seat of the arbitration, or to the law applicable to the arbitration agreement. These are just examples. Obviously, there are other laws that can be invoked as applicable to a specific issue. And but the main distinction that we want to emphasize here is the one between procedural and issues and substantive issues, because that distinction will already determine the possible application of a different law following that approach. And by defining the application of a different law, it would lead to the application of a different rule, possibly. So that is why it's important, in fact, to have different rules that, to consider different how to characterize how certain issues must be characterized as as procedural or substantive. In addition to the characterization as procedural as substantive for a particular issue or question before the arbitrators will also have to decide whether the particular issue must be resolved following a conflict of laws approach that I just described, so that you identify the national law that would eventually apply to that issue, or whether to apply a rule that is derived from the international arbitration precedents. So transnational arbitration rules applicable to arbitration proceedings. And sometimes, in fact, these transnational rules would be found mostly in the realm of procedural rules rather than substantive rules, especially when obviously the parties have already agreed on having a national law applicable to the substance of the dispute. So I guess let me give you an example of how this distinction can indeed affect the decision of the arbitral tribunal. The characterization of a particular issue as procedural or substantive can affect, for instance, the limitation period. The limitation period is a period within which a party must bring a claim. Depending on the applicable law, you would have different rules on limitation periods. And I provide here an example. In the UK, tort disputes, tort claims must be brought before court within 6 years, while instead in France, the period available is 5 years. So under English law, the rule applicable to limitation periods is considered a matter of substance. And so it's a substantive issue. So if if the arbitrator qualifies a particular issue as a substantive and English law is relevant, it may apply, in fact, to the limitation period. But there are other jurisdictions in which the limitation period is considered to be procedural rule. So if the arbitrator will qualify that particular question as a substantive, the jurisdiction, the law of those jurisdictions that consider it to be only regulated by procedural rules will not be applicable in principle. Another example, which is quite relevant, is the rules governing the admissibility of evidence. Under English law, Section 34(2) of the Arbitration Act of 1996 provides that whether to apply strict rules of evidence or any other rules as to the admissibility, relevance, or weight of any material, oral, written, or other, is a procedural matter. So, on the other hand, under French law, the admissibility of evidence is a matter of substance. And so the characterization of a question relating to the admissibility of certain evidence as procedural or substantive may lead to the application of French or English law. And as a result, a particular evidence could be admitted or excluded because of the application, because of the determination of the law that applies in this particular case. And admissibility of evidence is important because the possibility of submitting certain evidence to the arbitral tribunal can define the result on the merits, and for that reason it's a quite relevant aspect. Another typical strategy that parties would adopt in order to affect the merit of a case is by creating a series of procedural incidents. And some of the claims that are typically submitted to the arbitral tribunal is a bifurcation claims, or claims, for example, to stay the proceedings. The bifurcation claims are often filed with the arbitral tribunal in order to challenge, to have preliminary issues resolved before going into the merits. The fact of submitting a bifurcation claim could in fact make the arbitration more efficient if the bifurcation claim is successful, in the sense that the ground on the basis of which the arbitration was decided to be bifurcated, that means that a particular phase of the arbitration would be dedicated to a specific issue, and postponing addressing other issues afterwards. So in this, if the ground on the basis of which the bifurcation has been awarded is successful, obviously the arbitration proceedings can be said to be successful or efficiently conducted. But very often this is not the case, and bifurcation claims will affect the arbitration proceedings only by making the overall arbitration longer and more expensive. And if there is at the end sound right for one of the claimants, for the claimant, having bifurcated the arbitration will result in additional costs and additional frustration. So bifurcation claims, according to the ICC Commission on Arbitration, IDR, it requires particular considerations, and that is the likelihood that the separated claim can be determined without considering or affecting the overall merits of the whole case, the specific reasons for splitting the case and the parties' expectations as to the effect of doing so, and whether the split would delay or expedite the arbitral proceedings, and whether the split would increase or decrease the cost of the arbitral proceedings, and whether any proposal to split the case is a mere tactical device to delay the proceeding or not, and the prima facie likelihood of success of the party seeking the split if the parties are in disagreement or to splitting the case, as to the splitting of the case. And finally, whether isolating decisions specific to claim necessitate expeditious determinations for factual and legal issues. So bifurcation claims include, can in fact include decisions that can, determine additional costs of the arbitration. In practice, it is often useful for an arbitral tribunal to consult the parties' initial statements of case before making such a decision, and dividing the case. What actually we have when there is a bifurcation claim is the division of the arbitration into a phase dedicated to liability and a phase dedicated to quantum issues. But such a bifurcation should be, in principle, done only after discussion about causation, as many cases, causation can be classified into either phase. And for example, the expert evidence on quantum in relation to the rectification of alleged defects in a construction dispute, for instance, may in fact be relevant to liability. And thus, before a decision is made on bifurcating a case, the parties' arguments on causation and quantification should be known so that it is clear how the costs and losses are supposed to have a reason. A more aggressive initiative that a losing party can have is to initiate parallel proceedings in order to have the same dispute or closely related dispute decided by a different arbitral tribunal or by a national court. And the party could frustrate the ongoing arbitration proceedings by seeking to transfer the dispute to a national court or to obtain anti-arbitration injunctions. So that means initiating a new court proceeding on the same dispute or a closely related dispute before a national court in order to frustrate, to affect negatively the ongoing arbitration proceedings. Parallel proceedings could be also initiated by third parties in relation to the same or closely connected disputes to affect the arbitration proceedings. And this is in order to obtain a decision on the merits which can indeed affect the arbitration already ongoing between two parties. And for example, one of these decisions could be about the nullity of the contract from which as a reason the arbitration between the two parties, two original parties. And by having the contract declared null and void during the arbitration by a national court, that decision can in fact affect the conduct of the arbitration proceeding and interrupt any possibility for the arbitrators to continue and address the dispute. An example of disruptions encountered in a recent London arbitration in which I was involved can be interesting to give you an example of how difficult it can be in some cases to resolve a particular dispute. This was an ICC arbitration with a seat in London, which started in 2018. After having defined a long procedural timetable, because the defendant, the defendant was trying to expand the duration of the arbitration by claiming that they had 4 months for the holiday period, so they couldn't have hearings during the months of June, July, August, and September. So after having argued such a crazy delay for the procedural timetable, they introduced counterclaims and refused to pay subsequently the advance on costs defined on a separate basis for their own counterclaims. And that refusal came after having requested multiple postponements for the payment of the advance on costs, which took more than 1 year, so that at the end, the counterclaims were considered as withdrawn. Another initiative that the defendant had in this case was to file multiple applications for orchestrated or unsound procedural irregularities, also attempting to invalidate an expert opinion produced by the opposing side, that is the claimant. And all these applications obviously required a response, replies, and then a decision from the arbitrators. But on top of this, they also requested multiple postponements of the evidentiary hearing shortly before the hearing had to occur. And on the first instance, the reason was health problems by one of the key witnesses who was also a representative for the respondent. And subsequently, the second request for postponement was determined by the fact that by changing strategically its counsel, the counsel needed sufficient time to prepare for the hearing, even though the hearing had to take place 1 month, more than 1 month later. So not happy of these postponements, and having the tribunal denied the last postponement, they initiated judicial proceedings without notice against the claimant before Nigerian courts, and obtained from the Nigerian court an ex parte order prohibiting the arbitral tribunal from continuing the arbitration. And what is interesting in this particular case is that the order issued by the Nigerian court was not addressed to the other party, that is the claimant, but was targeting the members of the arbitral tribunal personally, so that they would have been in contempt of court if they were to continue any action in relation to the arbitration proceedings. So the order was not directed to the claimant. And in principle, the claimant could in fact continue the arbitration if the tribunal would agree to do so. But obviously pending an order on the members of the tribunal on a personal basis, the tribunal was in fact blocked in a situation where it couldn't act. And the order was ex parte, that means without any notice to the counterparty, that is the claimant, or to the arbitral tribunal, who were the members of the tribunal, who were in fact the addressees of the order. Following such initiative, they also submitted the Nigerian courts, the same Nigerian court that issued the ex parte order, some counterclaims which were previously withdrawn, were considered as withdrawn from the arbitration because of the failure to pay the advance on cost, and additional claims, additional counterclaims, which had not been presented at all in the arbitration. So in response to these various initiatives, the claimant applied to the English courts and for an anti-suit injunction, that is an order against the respondent, preventing the respondent from continuing the judicial proceedings in Nigeria, so that the anti-arbitration injunction order issued by the Nigerian court could be dismissed. And the English High Court issued this interim injunction with a penal notice ordering the respondent not to proceed with the Nigerian judicial proceedings because they were initiated in violation of a binding arbitration agreement, and in case of a violation of the order issued by the English court, the respondent would have been held in contempt of court, fined, or have its assets seized. The result was that the respondent decided to discontinue the Nigerian proceedings, and following that, they filed an application to the ICC challenging the independence and impartiality of the arbitral tribunal on the grounds that their conduct of the arbitration was partial or biased, so that they didn't give enough time to their counsel to prepare for the hearing, which in fact was not the case. And after the application was rejected by the ICC, the arbitral tribunal defined a procedural timetable which was communicated to the party, offering plenty of time to resubmit all the arguments that the respondent wanted to present for a duration that is almost another year. So what is an anti-suit injunction? It's an order of a court that prevents a party from commencing or continuing a proceeding in any jurisdiction or forum other than the contractually agreed forum. Failure to comply with the order may constitute contempt of court with serious legal consequences, including fines, seizure of assets, or even imprisonment in some cases, depending on the local law and on the test of the order issued by the court. The anti-suit injunctions can be used to prevent litigation, which has been initiated in violation of exclusive jurisdiction clauses. So, for example, where a contract provides for arbitration and one party initiates judicial proceedings before a national court, the other party may apply to another court of the seat of the arbitration for an anti-suit injunction. So, The initiation of judicial proceedings in a forum other than that contractually agreed upon constitutes a breach of contract. And on this basis, courts in common law jurisdictions have traditionally been willing to prevent foreign legal proceedings commenced in breach of arbitration clause. An anti-suit injunction, in order to obtain one in England, is necessary to convince the English judge that there is a valid arbitration agreement, that the arbitration agreement is binding on the party that initiated the judicial proceedings before foreign court, and that the court proceedings amount to a breach of the arbitration agreement. The English judge must be satisfied that the arbitration clause is not null and void under the governing law, which could be, in fact, not necessarily English law. Sorry. Distinct from anti-arbitration, anti-suit injunctions, is the anti-arbitration injunctions. So usually an anti-suit injunction is intended as a means to support arbitration proceedings because it prevents disruptions that result from parallel judicial proceedings. However, a party can obtain an anti-arbitration injunction, an anti-arbitration order from a court, prohibiting certain parties from initiating or continuing arbitration proceedings. So anti-arbitration injunctions have long been the subject of international controversy, and the practice has been condemned because of undue interference with arbitral proceedings. Anti-arbitration injunctions are usually challenged on the basis of the key principle of competence, which is generally applied to any arbitration proceedings, and expressed the concept that the arbitral tribunals are competent to determine their own competence. So in order to define their own jurisdiction, the arbitral tribunals refer to themselves, essentially. So parallel judicial proceedings is important because when there are arbitration proceedings commenced without an arbitration clause, a party can in fact obtain an anti-arbitration injunction to frustrate that arbitration and thus protect the interests of the party. But this kind of injunctions usually are often used or sought in order to protect national entities as a form of legal protectionism. So they do not, they are certainly not arbitration friendly. And in countries which are supportive of arbitration, such as France, courts have, courts have consistently refused to interfere with arbitration proceedings and would not issue anti-arbitration orders or injunctions. This is not the case in England, where the Court of Appeals of England and Wales held that English courts have jurisdiction to grant anti-arbitration injunctions against foreign-seated arbitrations. And they stated, the court stated, that an anti-arbitration injunction involves an interference with a different principle, namely the fundamental principle of international arbitration that courts should uphold and therefore not interfere with arbitration agreements. Where it is clear that the dispute is within the terms of a valid arbitration agreement, then the courts should not interfere. But when the converse is true, either because it is a common ground between the parties or because of a previous determination, the court may grant an anti-arbitration injunction, but only if the circumstances of the case require it. So this is possible in England under the situations, under the circumstances determined by the judge. So let me give you another case which is emblematic of the difficulties and that a party can encounter to obtain justice for its own case. This is a case that has occurred in Qatar, and it has been initiated by a subcontractor against the contractors of a particular project and the employer. The employer resisted the jurisdiction of the arbitral tribunal, which was finally asserted by the tribunal on the basis of its interpretation of a Qatari judgment, which referred both the contractors and the employer to arbitration. So the source of the jurisdiction of the arbitral tribunal comes from a decision rendered by a Qatari court, so a Qatari judgment, which referred both the contractors and the employer to arbitration. So after having lost a case and having received a partial award from the arbitral tribunal, the employer sought the annulment of that partial award and at the same time requested the arbitral tribunal to clarify the position on a very long, exhaustive list of legal issues which had been already decided in the partial award. So the result was, in fact, to obtain further clarifications with the, I believe, with the purpose of creating more grounds for increasing the chance of having the partial award annulled in Qatar. Not only the employer had these two initiatives, but also challenged the independence and impartiality of the arbitral award, of the arbitral tribunal, on the basis of the legal arguments and the language that the tribunal used in the partial award, recognizing, asserting the jurisdiction over the employer. Such a challenge has been rejected by the ICC, but not happy of the initiatives. The same employer commenced judicial proceedings before Qatari courts, asking the Qatari courts to provide their own interpretation of the first Qatari judgment that was issued years ago, and which was res judicata, and on the basis of which the partial award was based, and which was also res judicata. And finally, the employer requested, in relation to the same matter, the Qatari court, the same Qatari court which issued the original Qatari judgment, referring the contractors and the employer to arbitration, to modify some of the wording of the Qatari judgment and some key wording that would, in fact, affect the same nature of the decision. And such a request has been made before the Qatari court, notwithstanding the fact that that Qatari judgment is res judicata. That means it's a final and binding decision and rendered several years ago. So there are disruptions that can't be created by the parties. And sometimes also other parties, third parties, are involved in this attempt to frustrate arbitration proceedings. One case is, for instance, the attempt of enlisting third parties, such as shareholders, affiliate companies, private companies, or employees, in order to disrupt the arbitration. For instance, under Article 166.3 of the Russian Civil Code, a party who has a legally protected interest can file a claim to set aside a transaction containing an arbitration agreement. And if such a claim is filed in the Russian courts and is successful, it will have an impact, it may have an impact on the arbitration, because even if the arbitral tribunal has jurisdiction, it would be difficult for the tribunal to apply in Russian law, for instance, to the dispute, to disregard the decision of a Russian court on the same issue that is before it. So I hope you had some inspiration from these examples that I gave you, and I remain at your disposal for any questions that you might have now or later after the webinar. So I will stop sharing so that eventually you might be able to, we can in fact address the questions that, any questions that you might have.
Yes, thank you, Vereni, for the great presentation.
Thank you.
And we currently have a first question from Mr. Ali Al-Ayad, saying, is there any condition precedence in the arbitration agreement to be implemented in the event of disruption caused by any party, defendant, or a plaintiff?
Yes, usually there is. If I understand correctly your question, for any kind of procedural application or initiative that a party can have, that application or procedural initiative must comply with some conditions or some circumstances, because otherwise they cannot be commenced or filed. So for instance, if you want to start a parallel proceeding, you will have to make sure that the court, before a court obviously, that the court has jurisdiction on the case that you want to file, because otherwise you would be failing in that attempt to disrupt the arbitration, for instance. If instead your idea is to request a bifurcation of the arbitration, then also in that case, your application to bifurcate the arbitration will have to comply with certain requirements in order to be successful. So there are some conditions that will have to be satisfied in order to be in fact successful. But what is actually, I have to just make a comment here, in the sense, a general comment. My experience, I've been working on international arbitration for more than 20 years now. And I have noticed a very strong increase in aggressivity and in the way the procedures are conducted, more than in the past, so that parties seem to be more willing to drive the arbitration, to disrupt the arbitrations in any manner possible, even if those kind of initiatives and disruptions can make them to incur substantial costs. And this is, for example, the case with respect to the Qatari case I described, where the employer has commenced all these proceedings, spending several times more in terms of legal fees than the initial substantive claim for which the arbitration was commenced. So a settlement could have been concluded for 1/5 or 1/10 of the cost that is in fact incurring for having all these arbitrations. So sometimes it's quite crazy, and it's not clear why a particular party can be so commercially insensitive. So I don't know if it is a particularity of Qatar in this particular case. I don't know. Maybe you, Mohammed, can give us some example. What do you think about that?
In Qatar, mainly, you believe that the losing party is really try to prolong and like similarity to the Nigerian case. They try to prolong and postpone as much as possible, maybe to benefit from securing their own amounts before having a final award to be released. So yes, there is a lot of similarity in Qatar, and I agree in your opinion on this.
So there are some in the chat box. I don't know if you have it. There are some questions, so yes. People have asked questions rather than in the QA.
Yes. I will. I have also from Raja. He's saying, if I understood correctly, you sounded the English courts are not as arbitration friendly compared to France. The case you cited in my reading does not substantiate that point. Please clarify if I am wrong.
No, I'm not saying that English law is less friendly than France, that French law, absolutely not. But there is a difference in the approach. And the difference is, one of the differences is the one that I referred to, so that, for example, you can have an anti-arbitration order issued by the court more easily, or in any event, it's a matter of graduality, obviously, but you can have an anti-arbitration order issued by an English court, and you are unlikely to obtain that from a French court. Another main distinction is that French courts will not interfere in the arbitration or in the will not address any jurisdictional issues relating to an ongoing arbitration after the arbitral tribunal has been constituted. And so a French court typically would wait until a decision is rendered by arbitral tribunal. This is not necessarily the case from an English court. So there are differences, but nevertheless, these differences do not quite make the English courts less friendly towards arbitration than French law. This is not what I meant. So I have to reassure you that this is not the case.
We have also another question from Mohammed Fikki. He's asking, do the courts look into the merits of the dispute or the procedural rules apply to arbitration in order to decide on anti-arbitration injunctions?
Well, if the anti-arbitration injunction is sought during the arbitration and before the arbitral award is rendered, if relevant, the court would look into the procedural issues and also the substantive issues, the substantive claims filed in the arbitration, if they are relevant. In what way they can be relevant? They can be relevant in order to decide whether, for example, the anti-suit injunction can be issued. So, for instance, if you have an arbitration ongoing, and then you have a lawsuit started in violation of the arbitration agreement, and also a lawsuit where the party has filed the same claims, the same substantive claims that have been filed in the arbitration, the judge who has to render, to issue an anti-suit injunction to discourage the court proceedings to go on, will look at whether, in fact, the claims filed with the court are the same of those filed in the arbitration. So this is one situation where the judge will look at it, for instance. He will look also to procedural issues because sometimes procedural applications made within the arbitration by a party is the indication of the fact that the party is trying to, in fact, create tactical delays and disruptions for the arbitration proceedings. So to that extent, the court will also look at procedural claims or issues.
Yeah. There is a question from Sophia. She's asking, could the aggressiveness be due to the fact that the courts exercise case management issues and sanctions to the aggressor?
I'm not sure I understand what you mean here. Is the aggressivity increased?
Maybe like balancing, I think, the aggressiveness of the defense with what the court would issue, like in sanctions against the aggressive defenses a respondent would have to postpone or to delay the arbitration proceedings. I hope I understand her question correctly.
Yeah. I'm not sure this is what you mean exactly. I'm not sure.
She's asking about like, could the aggressiveness of a respondent in delaying the proceedings of the arbitration could, look, I say, be more defensive from the courts, or trying from the courts to do a case management and you can say impose sanctions against such aggressiveness from in response from the respondents or the aggressive party?
Okay. Well, certainly the courts and the arbitral tribunal can intervene in order to control the aggressivity of a party in, for example, disrupting the proceedings. That is for sure. But I thought she wanted to ask more whether the aggressivity of the parties is increased because courts are more hands-on in managing the proceedings in general. And so for that reason, the parties feel restrained for this increased management. But I don't think this is the case, really. If this is your question, Sophia, I don't think that's the case. I see that Ogbene Abang has participated, and thank you very much for your compliment. I really appreciate that. Sophia has clarified what she means. She says, more specifically, said that over the 20 years arbitration has increased. No, I was referring to the fact that I have more than 20 years arbitration experience myself personally. And from when I started my career, and what I can see in the last few years, I can tell you that the cases in which I was involved 20 years ago or 15 years ago, there was a lot of aggressivity between the parties, but the proceedings were less complicated to some extent. And overall, I mean, and there is more and more often now, for example, the tendency of a party to challenge the independence or impartiality of the arbitral tribunal than I saw in the past. In my past experience, you would really challenge the independence or impartiality of the arbitral tribunal only when there was a clear case of bias. And now instead, parties tend to apply for dismissing the arbitral tribunal just in order to try their chances. And so that's why it's a little bit more aggressive than in the past. This is what I meant.
In Qatar also, there is an increased amount of aggressiveness also. As you said, lawyers, when they believe that they don't have a strong case these days, they try all, you can say, the tricks in the book, trying to accuse the arbitrator, trying to asking to step down, challenging him for the language, for the impartiality, and trying to get some court order against him, just in a way to delay the process of the arbitration as much as possible. So it's getting more aggressive during the day. Mr. Raja, he continued again, and he said, S34 of the Arbitration Agreement, Arbitration Act 1996 is on evidential points, procedural. Again, to clarify, any foreign mandatory laws and substantiative immaterial from where if it is applicable to the matter. Hence, it would not be procedural, but mandatory and applicable compared to evidential matters. Any comments?
Well, if there is a mandatory rule, then it's a different matter. If the law, for example, English law in this particular case, is applicable to the dispute, and contains a mandatory rule, then it is very likely that the arbitral tribunal will have to apply it because of the mandatory character of that rule. The example I was referring to is not taking into consideration the mandatory character of a rule. But precedes that kind of analysis, in the sense that if you have not mandatory rules applicable, what kind of law you would be applying to a particular issue? So when you have an issue in front of you, you will have to decide whether that issue is a procedural one or substantive one. And depending on whether the issue is substantive or procedural, you might decide what is the law that applies. So typically what happens is this, that the tribunal would often apply, if an issue is procedural, the law of the seat. And when the issue is substantive, would apply the law governing the dispute. And so, for example, the law governing the contract. This is a simplified kind of example, the one that I'm giving you. Obviously, there are many different reasoning that an arbitral tribunal can follow. But if the issue, for example, of admitting an evidence is considered substantive, the law chosen by the parties to govern their dispute and their contract will necessarily apply because it was a law agreed by the party. But if there was no law agreed by the parties to apply to the procedure, to any procedural issue, and the admissibility of evidence is considered to be a procedural issue, the tribunal could consider that the law of the seat could apply to that particular issue, rather than the law of the contract. Or they could also, for instance, decide that they would apply a transnational rule deriving from arbitration precedents. So, because in fact, from a procedural point of view, the general principle is that arbitral tribunals are free to conduct arbitration proceedings as they see fit. So they are, to some extent, free to define what law governs the procedural issues. And see if an issue is defined as procedural, they can be free to define the law that applies to it, with the exception of mandatory rules and mandatory laws. So you are absolutely right that if there is a mandatory law that applies or mandatory rule that applies to that particular issue, that law or rules should receive application from the arbitral tribunal, because otherwise there is a chance that the arbitral award might be set aside because of that violation.
True. We'll take the final question from Mr. Iyad El-Hindi. He's asking us, usually the arbitration agreement in Qatar is used in agreements in not less than 500,000 riyals, because the nature of contracting and training running very well. So we can say that the cost fees of arbitration is fair. Is that right?
So I don't know whether you can have arbitration agreements in Qatar only for agreements of less than 500,000 Qatari riyals. Actually, I know that you can have arbitration clauses in contracts for more than that amount.
There is no limitations in Qatar for arbitration agreements to be made, yes.
Yeah, in terms of amounts of the dispute or value of the contract, I don't think there is a limit. If you are referring to a dispute, nevertheless, of 500,000 Qatari riyals, and you are asking whether the cost of an arbitration typically would be compatible with such a dispute of a low amount, then I can tell you that the typical costs usually are quite high. And a dispute of 500,000 Qatari riyals would be, it would be discouraging for a party to have a dispute for such an amount to have an arbitration, because the arbitration would be more costly than the amount of the claim. But this said, there are now many institutions, arbitration institutions, which are trying to encourage the settlement of small amounts, disputes for small amounts, through accelerated arbitration procedure, which would imply the expenditure of a small amount of fees and time. And some of these platforms allow also to have the dispute resolved without a hearing, or with a hearing, for example, a virtual hearing. So if you know that you are signing a contract where the dispute is likely to be of a small amount, and you want to have an arbitration clause, I would strongly recommend you to search for these alternatives, because they would be more compatible with the kind of disputes you are facing. Otherwise, it would be really just a frustration for you to resolve a dispute of that kind with a normal arbitration. So I hope Riyad has some, and if you want to have some information about the platforms or the accelerated rules, you can send me an email, which is indicated in the slides, and I would be glad to provide you with the information that you would need.
Thank you, Vernie. We thank you also for the great amount of information and literature we received in this session. We would like also to introduce Mr. Ahmed Al-Ansari to the session also for some closing statements. Engineer Ahmed, you are with us.
Maybe he's muted.
Mr. Ahmed. Let me ask him if he... Okay. So apparently Mr. Ahmed is out of reach at the moment.
Okay.
Okay. So with this, I would like to invite everybody who are attending this session to send any further questions to Ms. Veronique Colayotta for any clarifications or any further informations. Her email is shown at the screen at the moment. I would like to thank you very much, Ms. Veronique, for your valuable time, and looking forward to have more webinars and more insightful information in the future.
Nurul is asking whether there is the time for last question. Ahmad, we like to ask.
Let's see if we have another question.
We can stop sharing and having our face shown. Maybe it would be better.
Yeah. All right. I'll stop the share.
Hamad, we are all here and can listen to you.
Yeah, thank you very much, Virginie. That was very interesting. Sorry, I had to go away for a bit. I had some people working here in my house. I had to attend them. I hope that I haven't missed much, but I must extend the great appreciations and the gratefulness to Virginie this evening. She's done very good with us so far this year, very cooperative with the local branch. And I believe Virginie and I have been working together for many years, and we had many joint events together, and we are always looking forward to hosting you with us as many times as possible, I would say. And I must say that we are preparing a big program for 2022. I hope things get better, and it would be a great honor for all of us to have you down here joining us in one of our physical events. And may I extend a personal invitation to you to join us, hopefully, in the annual member meeting, which we plan to hold sometimes in April next year. And then I think it would be a great opportunity to have the forum and at the same time presentation from your side. And that's personal invitation from myself. Thank you very much, Virginie, and really look forward to seeing you in the future. And I extend my thanks to all attendees this evening and to Mohammed, Nurul, Franco, Sheila, I believe, I'm not sure if she's with us. They've done a great job in preparing and organizing this event this evening. Thanks a lot.
Thank you. I would like just to share final slide for our upcoming branch webinars. In October 12, 2021, we have a webinar called Arbitration, Persuading the Tribunal, and the speaker will be Mr. Wayne Clark. Also, we have another webinar coming up in 23rd of November 2021, and it is titled Conflicts of Interest for Expert Witnesses in International Arbitration, with our speaker, Mr. Julian Bailey. For anybody who's looking for any further information or registration, please visit CIArb official website, www.ciarb.org/events. I would like to thank Mr. Ahmed, and I would like to thank Ms. Fighini for her time. And thanks all the attendees for staying with us. Looking forward to see you in the future webinars.
Thank you very much to all, and thank you very much, Mohammed. That's the end of you. Thank you, Mohammed. Thank you, Mohammed. Good night. Bye-bye.